Have you ever wanted to know what provisions you need in an option agreement? Have you ever wondered what other provisions you may want in your option agreement? Have you ever wanted to know how to explain to a weary seller what some of these provisions mean? If so, stay tuned for all that and much more. Hi, I'm wdolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn. Welcome to our episode on option agreements with a special emphasis on the option agreement that I use with my investor clients. However, before we dive in, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Okay, a well-drafted option agreement with investor-friendly provisions is a document that looks different than those you likely would obtain from another investor or from the internet. From the lawyer's perspective, every transaction can have different facts or issues, and states have different laws, and each of these reasons could create the need for customizing your option agreement. When I created my option agreement, which we're going to review in just a moment, I worked with several of my highly experienced and respected investor clients to craft many of the provisions in a way that worked for them to get deals done, but still includes the protective provisions that lawyers want to see in an option agreement. Okay, so generally an option agreement must at a bare minimum be in writing, identify the optionee and optionor, be signed by both parties, adequately identify the property, include the purchase price, term, potentially condition of title, and consideration. Okay, so let's discuss my Delaware option agreement. Okay, so not surprisingly, this agreement is titled an option agreement. You'll see that right at the top of page 1. Underneath the title of the document, you'll notice an introductory paragraph that captures some of those key required items to have an enforceable contract. So let's take a look at it. All right, it starts with this option agreement, herein referred to as agreement, is made and entered into on. Now this is where you're going to insert the date on this first line here. You're going to complete the year. We have 2-0, and then you got to complete in the blanks there the other portion of the year. By and between. Now this first party is going to be the seller. So it could be one individual, could be two individuals, could be a company, whoever that party is, you have the responsibility to properly capture that party. That's why we always recommend that you have your attorney help you complete this form. But if you understand it well enough and you have some experience at it, you may be able to do it yourself as well. All right, now this address after the seller, so you'll see after the blank, comma, whose address is, and then another blank before we get the defined term owner. This is the mailing address for the seller. It's not the property that you're purchasing. There's a distinction here. And now we have you, the buyer, or in this case, the optionee, because it's an option agreement. So you'll see and blank, comma, a Delaware limited liability company. So I always recommend Delaware limited liability companies for real estate transactions. That's why that Delaware limited liability company phrase is preloaded in the agreement. However, if yours is a Pennsylvania LLC, change Delaware to Pennsylvania. If it's a Delaware corporation, change it to a Delaware corporation. When you're listing the company name prior to that, a Delaware limited liability company clause, make sure that you list the entire name of the company. Don't forget the designator at the end. If it ends in LLC or Inc. or Corp. Or whatever it is, make sure you include that designator. And then you as the buyer are defined as the optionee. Okay, so let's move on to section 1. Section 1 is entitled Consideration and Grant of Option Rights. So this is going to do a couple of things. Number one, it identifies the consideration or the purchase price for the option, not for the property. That's later in section 3. This is just the purchase price for the option. It also identifies the property where you're going to list the mailing address and the parcel number, and also explains that the optionee has the sole and exclusive right and option to purchase this property. Now let's go back to line 1. In consideration of the non-refundable payment of blank, this is where you're going to need to write the price. If it's $100, you'll write ONE space HUNDRED. And we already have the and 00100 loaded in there for you dollars. Now after the $sign, you're going to put 100. We already have the decimal point and the other 2 zeros there for you. That's how you complete that. Again, this is the option consideration, not the purchase price for the real estate. Okay, in section 2, we have the term of the option agreement. This is critical. You need to have a term. If you don't have a term, your option agreement can be void for violating the rule against perpetuities. You can't have an option agreement with no end. There needs to be a defined end. And I would be very careful about using trigger events as opposed to dates. You can get yourself into trouble with trigger events that can also violate the rule against perpetuities. That's why this one is drafted to contemplate a specific date. All right, so what you're going to do is on line 1, you're going to list the number of, in this case, years. You could change this to months if it's only a certain number of months as well. But in the first blank, let's say it's 2 years, you'd write TWO, and then in between the parentheses, you would write the numeral 2 for years, and then commencing on, and we have a date. What's the date it's going to start, and what's the date it's going to end? That way there's no doubt. You may have talked about a certain range of dates prior to this. The agreement may have a date on it. You may have signed it one date. The seller may have signed it a month later. We're going to remove all that doubt, and we're going to put the actual, not only the time period, but the beginning date and the ending date, so it's crystal clear to everyone involved what the time period is. Section 3, this is the purchase price of the real estate if and when you as the optionee become the buyer and decide that you want to actually purchase this property. So similar to what we discussed for the option consideration, on line 2, you're going to insert the text for the purchase price. So if it's $100,000, you're going to write ONE space HUNDRED. And we already preloaded thousand. I mean, I would hope that if you're buying real estate, it's in the thousands. It's not in the hundreds of dollars. And then after the $sign, you would write the numeral 100, comma 000. We already have the decimal point and the other 2 zeros. And that would capture your $100,000 purchase price for the real estate, which again is different than the consideration that you're paying for the right to have this option to purchase. Section 4 is really interesting, and a lot of thought went into this. There's different ways to deal with the issue that I'm about to describe. But first, let me tell you what sort of the issue is here. If you have an option agreement that doesn't cover all of the material terms, if you have any contract that does not cover all of the material terms, you run the risk that the agreement is unenforceable. That's particularly tricky with an option agreement because a lot of times when you're entering into an option agreement, you're not thinking about inspections, having some kind of contingency, and then when is that going to start? Are you going to inspect it in the beginning when you're entering into the option agreement, or later when you're ready to exercise your rights under the option agreement, right? If it's a long option agreement, you probably don't want to inspect it on the front end and then have years go by. Stuff could have happened to the property in the meantime, right? But a lot of times investors aren't really thinking through that. So if you don't have an agreement on whether and to what extent there's going to be inspection contingencies, financing contingencies, conditions of title, what's the actual closing time frame going to be, not to exercise the option or the right to purchase, but once you exercise that right, how long do you have to actually close? A lot of times this stuff isn't spelled out. So if you don't have enough of the material terms in the agreement, you might not have an enforceable agreement, which could be really problematic. You wouldn't even find out about it until potentially you're right upon the time to purchase the property. So you can deal with that in a couple of ways. You could have a purchase and sale agreement completed, all the blanks filled in, just not executed. And you could attach it as an exhibit to the option agreement and say something like, upon agreement between the parties, or upon exercise of the optionee's right under the option agreement, the parties agree to complete the attached purchase and sale agreement, or to execute it. So, but that's not what we did with this one, right? What we did with this agreement is we actually hardwired a lot of those terms into this deal, and they basically don't become effective unless and until the optionee exercises the option right. And once the optionee exercises the option right, then they kick in and they become effective. So we basically tried to consolidate this all into one document, but at the same time, still giving the optionee the right or the discretion to have the purchase portion of the transaction memorialized in an agreement of sale. And we build that right in because sometimes if you're using a lender or there's a financing aspect to this, you may need an actual purchase and sale agreement, or it may just be highly desirable to have one to make things move a lot more smoothly. But this is sort of a fail-safe provision to try to make sure that there's not going to be some argument later that there was not an agreement on the material terms of the transaction. So upon the optionee's exercise of the option agreement, this agreement here is deemed converted to an obligation to purchase the property, which basically means it's converted to essentially a purchase and sale agreement. So we also put in here that you're going to schedule a closing date for no more than 60 days after the exercise of the option. So this, again, this is important, right? You're not going to have this indefinite time frame because we don't want to have an agreement that violates the rule against perpetuities and is potentially unenforceable. We talk about here, it's going to be a special warranty deed. It's going to be free and clear of liens and encumbrances. And we go into a little bit more detail about the condition of title, right? These are all important things. This type of condition of title is critical to being able to make sure that you've got a good piece of real estate that you're going to be able to do with what you thought you were going to be able to do with it. All right, so let's move on to section 5, title exam and commitment. So this talks a little bit more about the buyer doing a title search and a little bit more about the condition of title here, which again is a very important part of buying real estate and something that you want included. So then section 6 talks about the costs and fees that are going to be paid in relation to the transaction. So upon optionee's exercise of the optionee's right an option to purchase the property, the owner shall be responsible for any costs to discharge any liens against the property, settlement charges, realtor or broker's commissions, as well as any costs and expenses as set forth in the agreement of sale, if there is one, if the parties elect to enter into such agreement of sale. Transfer taxes for the sale of the property shall be split equally between the owner and optionee. So this is, again, one of those important terms that can get missed. If that's generally not going to be included in an option agreement. Who's going to pay the transfer taxes? Well, in Delaware, transfer taxes are 4% of the sales price. So on a $100,000 purchase price, they're $4,000. So if the seller thought, just based on some kind of an assumption, hey, I thought the buyer was going to pay all that, and if the buyer thought, well, I thought the seller was going to pay all that, you could have a $4,000 problem between the two of you. So this sets out, it's generally customary that gets split between buyer and seller. It doesn't have to be. It could be sliced up any way that buyer and seller agree to. This document is drafted to contemplate that sort of customary way of doing deals, but you can amend it. But it's included in here, right? It's not an item that later on the seller is going to be able to say, we didn't have a meeting of the minds because we didn't ever decide who was going to pay the transfer tax, right? It's in here. Then we have also an explanation of prorations, that the liability for property taxes, water, sewer, and other lienable utility services are going to be prorated as of the date of the closing. That's generally in a purchase and sale agreement. It's an important component of allocating costs between buyer and seller. It's also necessary for a settlement agent to be able to to draft a settlement statement. This is like a roadmap for the settlement agent, and they need that information. All right, section 7, costs and fees paid by the optionee. Upon optionee's exercise of optionee's right and option to purchase the property, the optionee shall be responsible for the cost of the title insurance, title search, attorney closing fee, recording of the deed. This is all customary stuff, but we're just, again, we're laying it out so that there's not going to be an argument down the road. We never decided who was going to do what. If you're going to do something different on your deal, you need to change this, right? And I would always advise you to have your attorney change it. Whether it's you come back to someone like me who drafted the agreement, or whether you go to your closing attorney, whoever, make sure you have an attorney licensed in the state in which you're purchasing the property to amend this agreement for you. Section 8, possession of the property. Possession of the property shall be delivered to the optionee on or about the date hereof and governed by a lease agreement. So this option agreement is drafted to contemplate that it's going to be used with a lease, like a sort of a lease option type of situation, which is a very common strategy used by real estate investors, right? The lease option. Now, you don't have to have a corresponding lease for this document. So if you're not going to have a lease, then you need to change this provision. You could also just delete this provision, right? You could, where it says possession of property, you could write reserved, R-E-S-E-R-V-E-D, and delete this provision. Or you could say possession is going to be granted at the time of the closing of the purchase and sale of the property. That would be customary as well. Section 9, condition of the property and right to inspect. So this is important, right? Because this goes back to what I was talking about a few moments ago. When is the optionee going to have the right to inspect the property? When are they going to do that? On the front end? Probably not if it's anything more than like a 30-day option, because there's just going to be too much time for something to go wrong with the property, and then you're not going to get in the property what you thought you were getting, right? And that could be a big deal. So you want to have some kind of right. Now this is going to vary. So this is with, again, remember this document is drafted contemplating it is being used in conjunction with a lease, right? So in that case, you're going to have possession of the property the whole time, and it says that you can inspect the property at any time after the option agreement kicks in. So you have all that time to inspect the property. If you're not going to have the lease and you're not going to have possession, then this provision needs to be tweaked a little bit so that you can have access to the property upon exercise of the option, but prior to closing. Or if you want to have access 30 days before you exercise this option, maybe you could provide some kind of notice saying, hey, you're contemplating exercising the option within the next 30 days. You need access to do your inspections, whatever the case is, but this provision could be amended. Depending on what you're doing, should be amended, right? So it depends on what you're doing. And it makes clear here the optionee shall have the right and is authorized to make any inspections, surveys, soil tests of the property that the optionee shall deem appropriate in optionee's sole and absolute discretion prior to exercising such right and option. So again, this is drafted so that you do the inspection right before you're ready to exercise the option, and you don't exercise the option unless the property is in the condition that you're satisfied with, right? So this is different than a lot of other purchase and sale agreements where the agreement is effective and then you do the inspection and then you have a right to terminate the agreement of sale. This isn't drafted that way. It won't work that way. You can't exercise the option, do the inspection, and then terminate. You can't do that. This option agreement is drafted where you've got this time period before you exercise the option. You have access to the property, you do your inspection prior to exercising, and you make your decision at the time. You do the inspection, you say, I don't want to do it. I don't like the property. There's too many problems. There's things I didn't know about. There's things that got worse since the time I signed the option agreement, whatever the case is. You elect not to exercise the option. Don't need to terminate. You just don't exercise the option, right? An important distinction. That is an important distinction. If you're not going to get access to the property by way of the lease, again, this provision may need to be tweaked, okay? Please keep that in mind. Section 10 talks about access. So obviously, here we're saying the owner hereby authorizes, empowers, and directs the optionee to list the property on the MLS and otherwise market the property for sale and hold an event to attract as many potential optionees as possible during the term of this agreement. So this, it has, this basically contemplates the resale of the property, where you can, during your option period, during your right period, you can see if you can line up a buyer, right? To see if you can get somebody on the hook. You're under contract to purchase for 100. You're gonna see, can I get somebody to come and pay 120, 130, 150, whatever the number is, right? And if you get that party locked down, then you exercise your option and you're able to, close and resell. Or you can potentially do some kind of an assignment deal as well. And that's what we're going to see in the next provision. So section 11, optionee shall have the right to assign its interests under this agreement to any party without the consent of the owner. Upon such assignment, optionee shall have no further obligations to owner, and optionee shall be deemed released from all of its obligations under this agreement. Now, I will say, I really think that if you're going to assign this agreement, you should provide notice to the seller owner. You should give them timely notice. Do it quickly after you've assigned it. Give them the name, the contact party, reference this section, say, hey, pursuant to section 11 of our option agreement, I'm no longer liable under this agreement. This person is now your contact, and perhaps you even give them a copy of the assignment agreement. So you want to make sure, if you're going to use that part of the provision, that you do that. Know that if you don't use that, rather if you're planning to use that part of the provision and you don't provide any notice at all to the owner seller, it might not be enforceable for equitable reasons, because the owner has no idea at that point who he or she or it is in contract with. Right? And there could also be some issues that, you assigned it after there was a problem or whatever the case is with the seller. So you want to be careful about that. If you really plan to take advantage of that provision, you're going to need to provide the owner reasonable and complete notice. All right. So section 12, delivery of notices. So this is saying that, where are we going to send notices and what effect are these notices going to have? There's blanks here that I think are pretty simple. You're going to fill in, addresses and the like in this section. Section 13, entire agreement. This is saying that all the terms of the deal are in this agreement here and that there's not any outside terms. You always want to have that. You don't want a party saying, hey, there's another important term to this deal. We exchanged emails over it and here it is. Nope, what we're saying is, if those other email terms that happened prior to this, right, if they weren't incorporated in this agreement, they went away. And remember, that cuts both ways. So if there's something important that you had in emails, you need to make sure it makes its way into this agreement. It goes for conversations or anything, whatever it was. Always make sure it ends up in the agreement. Number 14, section 14, the representation section. Owner and optionee hereby warrant represent to each other that no real estate broker has participated in or pursued this transaction. No one wants to end up getting a letter from a real estate broker at some point saying you owe us a big chunk of money, right? Nobody wants to have to deal with that. And then there's an indemnity provision included in this, or indemnity clause rather, included in this provision as well. Section 15, attorney's fees. I always include attorney's fees provisions because it gives you more teeth if you want to enforce the agreement. So let's think through this. You want to go after someone to enforce the agreement. You'd rather be able to say, look, not only am I going to come after you for my damages, I'm going to come after you for all my attorney's fees and expenses for making me go through this, which sometimes can be expensive. They can be $5,000, $10,000, $20,000. Depends on the type of action and how difficult the other party is and how it all plays out. But you've got a lot more leverage if the other party has to calculate, okay, so if I don't have a great case, I'm going to potentially pay all of my attorney's fees, the damages, plus the other party's attorney's fees, and especially if you use that before the party breaches, right? If you get wind that someone is thinking about breaching, let's say in this case, the seller's getting cold feet. I don't know if I want to do this deal. I think I can get a lot more selling it to someone else. Then you can use this provision to say, hey, you're gonna pay me my damages, plus you're gonna pay all my attorney's fees. So you might want to think twice about violating this agreement. And that's the same conversation that seller's attorney is going to have with the seller as well if it gets to that point. Okay, governing law. So this just says that the agreement is governed by Delaware law. I don't think there's anything really controversial here. Section 18 is for additional terms. Again, I always recommend sit down with your attorney, make sure your attorney writes out whatever the additional terms are. If it's not worded well enough, clear enough, it may not be enforceable. Go through the extra effort. It doesn't cost a lot of money to have an attorney help you out with that. Number 19, recording. So this is really important for the optionee, that you want to have the right to either record this agreement or some kind of memorandum of this agreement in the Office of the Recorder of Deeds. That puts the world on notice of your interest in this property and prevents the seller from selling to someone else, right? It will put a cloud on title by recording either this agreement or a memorandum of it. Now, one thing to keep in mind, if you're going to do that, the document needs to be notarized. So this is only drafted as a right that you have, but if you're going to do that, you need to make sure notary blocks are included in this agreement and that the document is not only signed, but it is properly notarized. Otherwise, the county won't record the document. And same thing for the memorandum. The memorandum needs to be notarized or the county won't record the memorandum either. And you may ask, what's the benefit of a memorandum? A memorandum is a short form document. You could just explain you have an option to purchase the property for so many years, list the parties involved, the property address, the parcel number, put the legal description on it, but you don't need to get into the nitty-gritty on what the purchase price was and the condition of title and all these other provisions, which maybe you don't really want everyone to know that. Maybe you don't want to advertise that. And it also costs a little bit less to have a shorter document recorded. So, you'll save money by doing it that way. The next section, sealed instrument. So this, by making it a sealed instrument, this extends the statute of limitations from 3 years to 20 years. Section 21, counterparts, this says that you don't all have to sign the same sheet of paper. It also allows you to exchange signatures by way of PDF, and by the same token, you can use DocuSign or some other similar type of program. Now, I always recommend that in the end, you take the text of this document, all completed, you take whatever signature pages there are. Again, they don't have to be on the same sheet of paper, right? Unless it's like a witness signature, that has to be on the same sheet of paper as the signature of that they witnessed. But you put it all together, you scan it in, you make a PDF of it, and you email it out to all of the parties that are involved in the transaction. And you save that email. That way you have a record that this was the final agreement, and you state that in the email. Here is the final fully executed agreement attached to this PDF. The last page is the signature page. So here you have the space for the owner to sign, a space for the optionee to sign. We're assuming the optionee is a company, so you're going to fill in, or actually a Delaware LLC, so you're going to fill in the name of the company. Under that, where it says by, colon, and a line, that's where your signature will go. And you'll see name, colon, and a line, that's where you will type or print your name. And underneath that, title, colon, and another line, that is where you will print or type your capacity. You always want to make sure you list your capacity or your title for the company. It could be member of the LLC, manager of the LLC, president of the corporation, Once again, if it is a corporation, you need to change this from a Delaware limited liability company to a Delaware corporation. Over on the owner side, they're going to sign on the line that says seal at the end. And then it's going to, it says name : that's where you will print or type their name. Same thing for both parties. If there's more than 2 sellers, then you want just copy and paste those lines and add more of them to accommodate all the sellers that are involved in this transaction. All right, that about does it for our video on our option agreement. Please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. With that said, thanks for watching, and I'll see you next time.